Downloaded from outlinedapat.com. 1. Property Outline Spring 2015. Title: Fundamental Aspects of Property, Claims of Possession, Use and Control. Part 1. Possession I. Acquiring possessory interest A. By transfer, gift, or sale for value. 1. Compliance with statute of frauds. 2. Default assumption. Transferor conveys all of transferor's interest, unless limitations are express or necessarily implied from the circumstances. 3. If less than fee simple interest transferred to initial grantee, transfers to subsequent holders under that grant can be either A. Automatic, by natural end of preceding estate, or happening of determinable event, for instance, to A so long as used for residence, then to B by execution of right of entry. 4. Transfers of future interest. Although at common law several types of future interests were not transferable, most states now permit their transfer. 5. Resolving conflicts between grantees. A. Default. Priority is determined by time of conveyance, delivery, from grantor. First in time is first in right, based on theory that once grantor has conveyed that interest, grantor no longer has power to convey same interest to subsequent party. B. Recording Acts. 1. Establish system for recording interests. Determine which interests are eligible for recording. Specifies standard title search. Determines what parties are on record notice of. 2. Each state has adopted a recording system, along with a statute, that specifies when the default, first in time, rule will be overridden by a different priority. Race. As between two conflicting claims, the first to record a complete chain prevails. B. Notice. As between two conflicting claims, the subsequent purchaser, SP, prevails if SP had no notice at the time of purchase, and paid fair value for the property. I. In other words, did the last person in line purchase W/O notice of last claim? C. Race notice. As between two conflicting claims, SP must satisfy both the race and the notice requirements, in order to prevail over a prior grantee. 3. Forms of notice. Recognized by pure notice and race notice jurisdictions are actual notice, facts known by SP at the time of purchase. B. Record notice. What would have been shown by a standard title search performed at the time SP purchased. I. Start date in recording is not when they recorded, but when they received property. C. Inquiry notice. Facts known by SP at the time of purchase that would have led a reasonable party to investigate further. Such investigation would have provided SP with information about the prior inconsistent claim. I. X. If you're buying property and somebody is in residence of T you're buying, you have duty to ask them what their interest in property is, even if it's not perfectly reflected in the record. Downloaded from outlinedapat.com. 2. 4. Additional rules are wild deeds. Deeds recorded either too early, before the grantor holds title, or too late, after a conveyance out by the grantee has been recorded, are outside the chain of title, and are not treated as recorded for purposes of race or notice statutes. I. Early recording book example II. A B then OA. A sells before he legal title to convey, so B should be on at least record notice that there's a problem. AA. B isn't innocent but nonetheless sometimes B will record before OA. B. When OA occurs, estoppel by deed occurs, and A can't object to B's claim to title B/C he previously gave B deed to property. A has legal duty to transfer B. Shelter doctrine. In notice or race notice jurisdiction, if SP, B, takes without notice of prior grantee, A, then B may convey the property to subsequent grantees who have actual notice of A's adverse claim. I. Once A loses to B's line, on grounds of B having no notice, A is going to lose to any successor in B's line. C. Expanded title search through subdivision plat, where subdivision plat, map, is recorded. SPs may be on notice of promises made by developer that are contained in prior lots sold in the same subdivision, even if the promises are not included in the chain of title of each specific lot. I. Prior grants from the developer. Grants made before your lot was transferred. B. By capture or extraction of unearned thing or resource. 1. Default. First in time rule. Whatever standard applies, the first to meet it wins. 2. Actual possession. Physical control. Examples in rules for animals and natural resources. B. If found on an easement, did the easement include a right to capture provision? 3. Constructive possession. A. Wounding and continued pursuit of animal. B. Animal captured in claimant's trap. C. Customary standards for constructive possession. 1. For instance, gen. If animal killed, finders does not own, but should report whale, but finder is entitled to salvage fee, a share of value of whale. D. Animal or resources on land owned by claimant, so in constructive possession of claimant. 4. Duties to others in pursuit of good or resource. A. No intentional and unreasonable interference with others' opportunity to capture. 1. Keeble. Malicious conduct designed to drive away ducks. 2. Elif. Grossly negligent conduct that completely wasted oil and gas reservoir. C. By finders. Comparison of F's rights against others who may have claim. 1. Against true owner. 2. To prevails unless property has been abandoned by 2. If property is lost or mislaid, to has right to reclaim property or the value of property if finder has sold the property. 2. Against landowner. Low, but recall that 2 will still typically have better claim than either A. If finder is trespasser, low will prevail. Exceptions typically undermine idea that finder is actually a trespasser and end up saying finder had at least implied permission. B. If finder has permission to enter, is act of discovery within scope of finder's permission. 1. Is the object found embedded in soil? Unless F had express right to dig and extract objects, low prevails over F2. Is the object found in private area that F would not be expected to enter? Then low would generally prevail on reasonable expectations. Downloaded from outlinedapp.com. 3. Is the object found in place that other visitors would deposit personal items? McAvoy v Medina. With respect to mislaid objects, low prevails over F. To more likely to remember where mislaid and return. B. Low may have duty to take custody and secure 4 to 4. Is the object found lost or abandoned in public area where F is invited and low has no special responsibility for the goods of visitors? Then F would prevail. 5. Resolve other context by best arguments from analogy. 3. Finder is tenant. T. Claim against landlord. Lines. A. Personal property of lines left in home does not belong to T unless specified in the lease, even if objects had been previously lost and are now found by T. 1. Rests on idea of constructive possession. Personal property assumed to be landowners in absence of proof otherwise. 2. Didn't apply in Hannah v Peel because lines had never taken actual possession of property, so no basis for presumption. Question. How long would Peel have needed to be in possession for presumption to attach? B. If lost property is embedded within soil, belongs to lines over T, unless lease specifically granted T the right to extract from the ground. C. If lost property appeared on land after beginning of lease, T has better claim. Burden for showing timing varies among jurisdictions. 4. Against subsequent finders or thieves. A. If finder loses the property, F has the right to recover property from F1, subject to the right of T to recover from either of them. B. If finder's property is stolen by thief, F has the right to recover possession from thief, along with any enhanced damages for intentional theft, even though 2's claim is superior to both. 5. Finder is employee. E. Claim against employer. A. If EE is working on E's property, then rules of low and F will apply. B. If EE finds object while performing tasks specifically directed by then typically has better claim. C. If object found outside scope of directed work for then EE should have reasonable chance against but law quite varied. 6. Transfers by finders. F has the right to transfer all F's rights, but not those of 2. A. If F sells to B1, to may recover property from B1, who will have power to sue F for sale of property that F did not own. B. If F entrusts the property to merchant, who converts property and sells it to BFP, F may not recover the property from BFP, but may recover damages from merchant. UCC 22403. On these facts, T would be able to recover the object from BFP, because T did not entrust the item to the merchant. The rule only affects the claim of the one who entrusts property to the merchant. The entruster is barred from recovering the property from the BFPD by adverse possession. 1. Procedure may be raised as defense to ejectment or affirmative claim to acquired title. If AP prevails over TH, title vested in AP 2. Element, common law gloss added to statute of limitations for recovery of possession. A. Actual entry and uses average owner 1, measured by standard of ordinary owner 2, determined by range of actual and permitted uses in area 3, may be defined by statute. New York, enclose or improve. 4. Functions. Downloaded from outlinedapp.com. 4. Determine reliance interest of app. B. Ensure that TH is on notice that app claims possession. B. Open and notorious. 1. Use must be publicly visible. Give TH opportunity to see that app is possessing. 2. Different standard for subsurface intrusion. Actual notice. 3. Some jurisdictions also have enhanced notice requirements for boundary disputes in built-up areas. Manila. C. Continuous for statutory period. 1. Measured by standard of ordinary owner's usage. Occasional absences do not disrupt continuity. B. Seasonal use depends on whether sufficient evidence of presence with intent to return. Howard v. Canto. C. May include tenancy of someone app leases land to. 2. Tacking. Current app may combine time and possession. with predecessor, if the two are in privity. A voluntary transfer from App 1 to App 2 B does not require writing conforming to statute of frauds. D. Exclusive of TH1. Possession is not shared with TH if TH or any other possessor is on property without app's permission. 2. Standard is conduct of ordinary owner. For instance, not objecting to every crossing by hiker is okay for app, merely being hospitable. E. Hostile. Claim of right / Title 1. Objective test. App does not have permission of TH2. Subjective tests. Good faith. Gap. New York. App must enter and possess with good faith belief in right to possess the property. B. Bad faith. Rejected. App must enter with intent to possess property that app knows belongs to someone else. F. Color of title. Additional statutory form of adverse possession. Same element as app, except 1. Enter under document that purports to convey title. 2. Typically requires good faith. Has shorter statutory limit. 3. If some portion actually possessed, may get constructive possession of full lot described, but CP 163. 3. Disabilities. A. Certain conditions, specified in statute, may delay, toll, start of adverse possession clock. B. Disability must be present when app begins. C. Disability only delays clock. It does not eliminate app. 4. Adverse possession of personal property. A. Special considerations for app of personal property. B. Different statute. Statute of limitations. Relevant. C. Main consideration. When does app clock begin to run? 1. NJ rule. O'Keefe. Discovery rule. Clock starts when TH knew, or should have known, by taking diligent steps to recover good. 2. New York rule. Guggenheim. Demand rule. Clock starts to run only with demand by TH. 4. Relevant. D. But same result as app of real property. If app claim succeeds, then title shifts from TH to app. Downloaded from outlinedapp.com. 5. Second. Rights of possessors. Trespass. A. Exclusion. Entry only with consent of possessor. Law of trespass. B. Exceptions. 1. Emergency or necessity. Plouffe v. Putnam. Fire department access. 2. By consent of possessor. A. Leasehold interest. Lose right to completely control tenants' visitors. B. Place of commerce. Federal, state and local non-discrimination laws may limit ability to exclude unless possessor has legitimate business-related reason for excluding. 3. The shack exception. Farmers' control over migrant workers creates intolerable vulnerability, protected by common law right to receive visitors and public assistance while residing on farmers' property, but that right is balanced against farmers' legitimate business needs for safety and security of worksite. C. Remedies for breach. 1. Damages for retrospective harm. Restitution principle. A. Default measure. FMV diminution in value of property. B. If possessor held property for personal use, then measure may be restoration, even if costs greater than diminution in FMV, and perhaps even if greater than total FMV of property. Brusau-Ankin. C. If possessor can show that trespass was in bad faith, with specific intent, and for personal benefit of trespasser, then may receive enhanced damages. 1. Disgorgement of benefit earned through wrong, unjust enrichment. 2. Punitive damages if conduct is especially antisocial. 2. Injunction to bar future intrusions, or have specific performance to remove existing intrusion. This prospective relief is strong default, making functional the right to say no. 3. Exceptions to injunctive relief for trespass. A. Minor encroachment. Relative hardship. 1. Innocent intrusion. Good faith mistake. 2. Disproportionately high cost to remove intrusion. 3. Relatively little harm to TH's property. A. Value of land taken is significantly less than cost of removal. B. Intrusion does not materially impede TH's use of property. 4. If shown, TH gets FMV of land taken. B. Innocent improvement. 1. Innocent intrusion. 2. Injunction will unjustly enrich TH. 3. If shown, TH gets choice by improvement. 4. FMV increase attributed to structure or sole land. 4. FMV. Third. Rights of possessors. The power to transfer. A. By default, grantees are assumed to have the power to transfer their interest. Any restriction on the power to transfer, a direct restraint on alienation, must be made express in the grant. B. Types of transfer. 1. Inter vivos. The transfer takes effect during the grantor's lifetime. 2. Post mortem. The transfer takes effect after the grantor's death. Even though a will is made during the grantor's lifetime, the will does not take effect until after the grantor's death, so gifts in a will, as well as intestate transfers to heirs, are post-mortem transfers. C. Types of direct restraints on alienation. Assume grant is O to a plus restraint on alienation. Direct restraints on alienation, DROA, are divided in 2 different ways. 1. By the rights of grantor and grantee under the DROA. Downloaded from outlinedapp.com. 6. A. Disabling, worded as a shall not have the power to transfer, or this property shall not be sold, mortgaged, leased, or otherwise transferred. Grantor presumably has no power to release A from this restriction. The land is simply bound up. Any attempt by A to sell/transfer would simply be void. B. Forfeiture to A so long as the property is not sold gives O the power to retake possession as soon as A sells. C. Promissory. A promise is not to transfer the property. Typical in landlord-tenant law. 2. Extent of interference with the power to transfer A. Total. Completely deprives A of the right to make transfer. B. Partial. Leaves A with the right to make some class of transfers, but restricts others. D. Validity of drawer 1. Disabling restraints are generally disfavored. They'll either be struck down, or in the case of leasehold, interpreted as promissory restraints. 2. Forfeiture restraints. A. Imposed on a leasehold or life estate, upheld if it serves as reasonable purpose. B. Imposed on a fee simple estate. 1. If total, then struck down. 2. If partial, ask. To what extent does it impair the possessor's ability to make transfers? B. Does the restraint serve a legitimate purpose, such as improving the overall marketability of land in a development or units in a condominium? C. If the restraint is overly restrictive, or does not serve a reasonable purpose, it will be struck down. 3. Will a restraint on use be construed as drawer? For example, O to A, so long as the property is used as the headquarters for grams. Charitable grants are almost never construed in that way, but transfers to commercial entities can be given that interpretation if it requires that the same entity hold the property. 4th. Rights of possessors, dividing up the right to possess over time. A. Basic possessory estates. 1. Fee simple, potentially infinite duration. 2. Life estate, duration determined by length of measuring life. A. Measuring life is almost always that of grantee. O to A for life equals A's life. B. But can be life of another. O to A for life of B equals B's life. 3. Leasehold. Types of tenancies. A. Term of years. To T for 1 year. T's control ends after 1 year. B. Periodic. To T from month to month. T's control automatically renews every month, unless either lines or T gives notice to quit. Notice must be equivalent to what the period is. C. At will. To T for $10,000 per annum, payable in advance on January 1st, until such time as either T or lines shall elect to terminate the tenancy. 1. Traditionally an option held by either T or lines implied an option held by both. 2. But some jurisdictions allow express intention of the parties to give option only to one. Typically, T. Garner. D. At sufferance, when T holds over after expiration of term. Significance. 1. No adverse possession, even though other tenancy ended. 2. T's holdover gives lines options. A. Elect to create new tenancy. B. Impose statutory penalties on T for failure to vacate. Downloaded from outlinedapp.com. 7. B. Interpreting ambiguous grants. 1. Unless circumstances strongly indicate otherwise, preference for least restrictive grant. In O to A, assume that O has granted all interest to A, that O had to. In particular, presumption for fee simple, and against life estate. If O wants to create life estate, needs to make that limitation clear. C. Inheritance of fee simple. 1. Heirs, spouse, and issue. 2. Ancestors. 3. Collaterals, blood related to decedent. 4. To the state, where property is located. D. Defeasible estates. 1. Any possessory estate can be made defeasible, but the limitation must be express. Courts will not imply forfeiture terms, just like courts will not imply time limitations unless expressly stated. 2. Defeasible estates are divided in 2 different ways. A. If the forfeiture event happens, does the property return to the grantor, or does it go to a third party? 1. If the grant doesn't expressly answer this question, then the property is deemed to return to the grantor, on the theory that you fill in any gaps by putting the property back into the grantor's hands. 2. Example, O to A4, so long as the property is used as a school, this explicitly states a feasible grant, but because it doesn't specify who takes, if A ceases to use the property for school purposes, the grantor, O, holds that future interest. 3. If a third party is named as the person to whom the property is transferred upon forfeiture, then A's interest is called an estate subject to executory limitation. B. If the property comes back to the grantor, is a forfeiture term phrased as a grant for a certain duration, so long as the property is used as a school, or as a permanent grant, subject to a restrictive condition. 2a. But if the property ceases to be used as a school, O has the power to retake. Although these look similar, and modern authorities, and some states, say that they should be treated identically, there have traditionally been 2 practical differences. 1. The duration type. An estate determinable ends automatically on happening of the condition, but the condition type, an estate subject to condition subsequent only ends when the grantor seeks to re-enter possession. 2. If the restriction was on a fee simple interest, the automatic end of duration type estates means that the current possessor, A, becomes an adverse possessor as soon as the forfeiture condition happens. If the grantor fails to take action within the statute of limitations, the current possessor holds a fee simple free of the prior forfeiture condition. If the restriction is placed on a leasehold or life estate, the implication of the grantor's failure to act would usually mean only that the restriction is removed, not that the possessor suddenly gets a fee simple. If it's a condition type restriction, however, the possessor doesn't become adverse until the grantor seeks to recover the property. That said, all jurisdictions seem to impose, through equitable doctrines of laches or estoppel, some limit on the time a grantor has to enforce a condition type restriction. 3. Transfer of defeasible estates. If A grants to A, so long as the property is used as a school, we know that A has a defeasible estate with a duration type restriction. A. If A transfers her interest to B, the restriction remains, so B now has property, so long as it is used as a school. O's interest remains the same. Automatic recovery if the property ceases to be used as a school. Downloaded from outlinear.com 8. B. Although the restriction on A's use would limit the number of people likely interested in acquiring the property, that grant would not be treated as a direct restraint on alienation, because it does not expressly restrict A's power to transfer. It is a restriction on use, not transferee. Future interest 1. Held by grantor A. Following the end of an estate that has a natural conclusion, leasehold, or life estate, reversion. B. Following the termination, or terminating condition of a defeasible estate. 1. If the defeasible estate uses language of duration, possibility of revertere, takes effect automatically at happening of condition B. If no action taken to recover property, period of adverse possession begins immediately. 2. If the defeasible estate uses language of condition, right of entry A, gives grantor power to decide when, and if to seek recovery B. Although adverse possession does not begin immediately, courts may still impose equitable limits on time after forfeiture event for grantor to seek recovery. 2. Held by grantee A. Following the end of an estate that has a natural condition, remainder 1. If remainder held by unborn or unascertained person, or is subject to condition that must be satisfied before taking possession, then remainder is contingent. 2. If not contingent, remainder is vested, but still divided into 3 subtypes. Vested indefeasibly, no condition subsequent will deprive holder. A vested remainder or possession. B. Vested subject to divestment, even though vested. Language of grant states condition under which holder may forfeit interest before or after it becomes possessory. Example, O to A for life, then to B, but if B fails to graduate from college before reaching 25, then to C. B's remainder is vested, but may be divested without ever becoming possessory. I. If there's a gap before condition can be met, then it's not a remainder. C. Vested subject to open gift to a class, which remains open, but has at least one known member. Example, O to A for life, then to the children of B. B is alive and has one child. C has a vested remainder subject to open. The unborn children of B, if any, have a contingent remainder. I. Class closing, depending on state statute. A. Natural, at the time of B's death, or B. Convenience, as soon as the first interest becomes possessory, even if B is still alive. B. Following the end of a defeasible estate, executory interest 1, treated for practical purposes like a duration type future interest would be, if held by grantor, automatic forfeiture on happening of terminating event. 3. Transfers of future interests. A. Despite the Illinois rule in Mendenhall's, most jurisdictions permit the transfer of all types of future interests. B. The identity, name, of a future interest is determined at the time of its creation. Thus, if O conveys to A for life, then to B and B subsequently conveyed her interest to O, O would have a vested remainder. Downloaded from outlinear.com 9. V. Relations between holders of successive estates, present and future interests. A. If the possessor holds a defeasible fee simple, the possessor has no obligations to successive interest holders, that is, there is no claim of waste in this context. B. If the possessor holds an interest that will have a natural end, a lease or life estate, the possessor has an obligation not to waste the property. The possessor has the right to benefit from the current use of the property, but must care for the property in a way that the future possessor's interest is not diminished. C. Waste comes in 3 flavors. 1. Permissive. The current possessor has failed to maintain the property, resulting in its decay and harming the future possessor or possessors. The current possessor's obligation to preserve the property has two facets. A. Use the resources generated by the property, such as fair rental value, to maintain the property. But if the maintenance costs exceed the current user's benefit obtained from the property, she has no obligation to use her own resources to maintain the property. B. In the case of necessity, the current income is not enough to maintain the property. The current possessor has an obligation to notify the future interest holder of the shortfall, and if the future interest holders are unwilling to make up the shortfall or waive liability for waste, bring an action to declare that her obligations are limited to the current amount derived from the estate. To affirmative, the current possessor has taken actions that diminish the value of the estate to the future possessor or possessors. A. With respect to sheer destruction, there are no complications. The current possessor is simply liable for the damage, and liability will be measured in the way it would be for a trespasser, except that many states also impose statutory enhancements, which double or triple the damages owed for waste. B. With respect to removal of non-renewable resources, such as timber or minerals, the current possessor would also be liable to waste unless 1. The grantor expressly allowed the current possessor to extract. 2. The extraction is defensible as good husbandry, clearing some trees, in order to allow the remaining trees to get bigger, and thus more valuable for the future possessors. 3. The extraction falls within the open mines doctrine. The grantor had an existing extractive operation that is deemed to continue, and the current possessor gets the benefit of that extraction during the possessory period. B. But the current possessor may not increase the rate of extraction or open new mines/wells, even if the old extraction source has been exhausted. 3. Ameliorative. The current possessor takes actions that materially change the structures or use of the property, but the change enhances the economic value of the property for the future possessors. A. At common law, this was still actionable, and the current possessor, or his estate, could be ordered to restore the prior use, or pay damages for the change. B. But most states now permit reasonable changes to the use, even if it involves substantial alteration of the property, provided that it actually improves the use of the property. 1. Unless the grantor expressly barred it. 2. Or the future possessors have some reasonable and foreseeable subjective basis for claiming an interest in having the property delivered to them in an unchanged condition. Example: O2. A life estate in the family home, to be passed on within the family. C. A material change in use will be especially defensible if the surrounding property uses have also changed considerably during the life estate, rendering continued use in its received